Well, Zuma's lawyers are asking the court for medical parole owing to his reportedly failing health. And the Supreme Court of Appeal has heard the case yesterday. Now, former head of the South African Correctional Services, Fraser, had dismissed a recommendation by the Medical Parole Advisory Board that former President Jacob Zuma did not qualify for medical parole. Criticisms have come in for Arthur, as they say he's not in the capacity to reject the board's recommendation. The board's recommendation was believed to have been based on the reports of 5 specialist doctors. Now, Fraser is reported to be a known ally of Zuma, and he authorized the parole on the 5th of September, just 2 months after the former president was imprisoned for 15 months for corruption cases. At the time of granting Zuma a medical parole, he was neither incapacitated or suffering from a terminal illness. Zuma has been ordered back to jail to complete his sentence, which will end in less than 2 months. But there are fears that the decision of the Supreme Court of Appeal may incite violence again. South Africa's Department of Correctional Services and Zuma have appealed against the decision. Joining from South Africa is Reiner Duvenage, who is a campaign officer at Afriforum, and we have Mzwanele Manyi, who is a spokesperson for Jacob Zuma Foundation, plus Nabila Mia, who's she's the head penal reform program at Lawyers for Human Rights. Ladies and gentlemen, welcome to the square. Let's start with you, Reiner. Afriforum instituted a case against Zuma's medical parole. You're in the spotlight with your group. So, what do you make of the Correctional Services decision to grant Mr. Zuma a medical parole?
Yes, Sulaiman, thank you so much for having me on the show, and good evening to the viewers. Yes, so we took this matter to court, like you mentioned. The decision to grant the parole was taken by the former National Commissioner of Correctional Services, Arthur Fraser, despite the fact that the Medical Parole Advisory Board, which is tasked by legislature to exactly determine these matters pertaining to medical parole, found that Jacob Zuma was in fact not terminally ill. And we then took this matter to court. Arthur Fraser overruled this decision by the Medical Parole Board. He took the decision, but he did not provide sufficient justification. He did not provide his rationale. He did not provide any, we did not provide sufficient record of how he reached this decision to overrule and to not take into consideration and the parole board's recommendation. So this matter was then in court in the North Gauteng High Court, and the court then ruled that yes, this did not pass the rationality test, and that it was in fact unlawful for Mr. Fraser to grant former President Zuma parole. And we strongly believe as an organization, we are a civil rights organization, one of the largest, we believe we're the largest in terms of membership in the Southern Hemisphere, and we strongly believe that politicians should be held accountable like every other single person in society.
And Africa is watching. Before I leave you, let's stay with you for a bit here now. And, you know, some Africans are wondering, asking if Mr. Fraser, is, apart from the job he's known for, is he a medical doctor?
No, Mr. Fraser is not a medical doctor. He has no medical expertise. He has no medical knowledge. In fact, and this is something I want to inform your viewers about, is that Mr. Fraser was caught lying on his CV that he had received a degree from the University of London, whereas he in fact had never set foot at the University of London. So Mr. Fraser, he has this record that he lied about his qualifications, and he is not a medical doctor. So certainly the Medical Parole Advisory Board, tasked by legislature, is the best body to make this call, and its decision should be the determining factor in granting parole. It found that Mr. Zuma was not terminally ill.
Mzwanele, let's, do you think your appeal has enough substance to it?
Yeah, good evening to all of you and to the viewership. Firstly, let's correct something in your intro. Arthur Fraser is not an ally of President Zuma. In fact, in the position where he is in now, he's been appointed by President Ramaphosa. So let that be clear. So to say he's an ally is just a propaganda peddling. So let's just put that aside.
But I'm sure that, sorry again, but I'm sure that's not the first time you're hearing that. People have been saying that in South Africa, right?
Every time they say this, I correct it. Every time they say this, I correct it. So don't worry, you're not alone. You've been feeding from the mainstream media, which has been misleading people, just like this spokesperson or this person from Afriforum here is just misrepresenting the facts. What are the facts? The facts are, number one, that Arthur Fraser, you see, in terms of the Correctional Services Act, Section 75 of that Act is very clear that all offenders that have got incarceration terms of 24 months and less, the person with a mandate to give parole to those people is the National Commissioner, which is Arthur Fraser. So when Arthur Fraser makes that ruling, makes that decision, he makes it in terms of Section 75 of Correctional Services Act. Now, that Section 75 Correctional Services Act is also read with Section 79. Now, in Section 79 is the criteria that is being used that must be put together. So the two things put together. First, the authority, the jurisdiction he's got in terms of the law. And the guy from Afriforum, if he has got anything to say, he must say it. I'm quoting the law. Section 75, in fact, can even go give you a subsection 7 as well of that act. Gives him the authority to do this. And then Section 79, subsection 1 of the same act, then gives Arthur Fraser this ABC of that to say what are the things that they must go through in making this decision. And one of the very pivotal things in this decision is the issue about terminal illness. Now, in terms of that, Arthur Fraser relied on 2 reports, actually, if not 3. The one report was from the medical examiners, doctors, that actually examined President Zuma, and they diagnosed him with a terminal condition, as it were. So he had that on the one side. And there was another doctor again. The first doctor, I think, was Dr. Mafa, and another doctor, Dr. Mpati. Both of them, they agreed that he's got this terminal illness. And it so happens that this Dr. Mpati, by the way, is also a member of this medical advisory panel. Then you have this medical advisory panel that had a different view on the matter. Now, what Afriforum and all of these right-wing groups have got a problem comprehending, they've got a difficulty in comprehending that a medical advisory board is an advisory structure. So anyone that knows anything about anything would know that when you're an advisor, you can't have an executive authority. So all advisors, you advise, you depend on the principal. I mean, recently in South Africa here, we had the president of the country who was advised not just by some advisory board, by a judicial services commission. This is a constitutionally constructed structure. It advised him on which person to appoint as the Chief Justice of this country. And he decided not to go that route. He took his own decision. And no one is saying anything about that, purely because the mandate, the original power lies with the president. Similarly here, the original power to make this
let me jump in here. I'm still with you, Mzwanele. Let me bring in this, because Section 75, you know, the ABC and subsection 7 that you just reeled out. Let me ask, has there been any known case of Mr. Fraser ever giving such medical parole to someone else before now?
Well, he's new. He was new in the position, by the way. He was appointed by President Ramaphosa in, I think, April of 2018, as it were. So
it looks like this is his first medical parole granted to someone, and it has
yes.
And this is
I don't know of any other. I only know of this one, but that's neither here nor there. The issue is, did he operate in a manner as prescribed by the law? Firstly, did he have the jurisdiction? Answer is yes, Section 75. Secondly, did he have any medical, it doesn't have to have any medical anything. It just has to have a medical report that says what it needs to say. He's got a conflicting medical reports. This is the point that these right-wing groups don't want to tell the public properly. He had 2 conflicting reports, but then I think he must have put weight on the report of the people that actually examined and diagnosed President Zuma. And after they've done that, in their own report, they then redacted some of the things because it's all crucial matters. This parole board people, this advisory parole board did not even have all the information as it were. They sat there with a redacted report. This is the same redacted report that they took to court. So both of the court.
Let me bring in Reiner again.
Both the board and the medical and both the medical parole board and the court. They had
Mzwanele, I'll surely come back to you. Apologies for button. Let me bring in Reiner again. You've heard him, but you and your group insist that there's no illness. That's not terminal illness. And he said that there are doctors who confirmed that the former president is terminally ill.
Yeah. I want to correct Mr. Manyi on a number of different points. In the first place, I think it's not very fair to just label us as all as right-wing groups. One of the groups is the DA, which is the main opposition party. So you can't just call it a right-wing group. That's the first point. The second point is his explanation that the Medical Advisory Parole Board did not have access to information is simply false. The Medical Advisory Parole Advisory Board did have access to all the information. The court did not have access to information, but the Medical Advisory Parole Board did have access to all the relevant information, and they made a recommendation based on all the information. Now, another point that I'd like to get into is that Mr. Zuma's own doctor, he mentioned that, he did not even explicitly state that Mr. Zuma had a terminal illness. He mentioned in the doctor's notes, you can see it says he had a terminal illness or a chronic condition. So it doesn't explicitly state that Mr. Zuma is in fact terminally ill. Then it's all irrelevant, even if Mr. Zuma's doctor did in fact state this. The legislation is clear. Mr. Manyi referred to the Section 79 of the Correctional Services Act. Section 79 says you need an independent doctor's report. So because it's Mr. Zuma's own doctor that wrote the report, it cannot be seen as independent, but also you need the recommendation of the Medical Advisory Board. So the Act is clear in this regard, and it made its recommendation. And there's no rationale. There's no way that Mr. Fraser also did not rationalize the fact that he overturned this decision. So on a number of different levels, it does not pass the rationality test.
Let me bring in Nabila here. Nabila, thanks for your time, and apologies for putting you on this, because we understand that, the lights are out in your neighborhood. But again, quickly, thanks for staying with us. And this has to do with looking at the Correctional Services Act. Help us have a better understanding what the Act says on releasing inmates on medical parole.
Okay, thank you very much for inviting me to be on your show, and my apologies. We have what is called load shedding here, so I'm sitting in the dark at the moment. But to get back to the matter at hand, Section 79 of the Correctional Services Act governs medical parole, and it provides that any sentenced prisoner can be considered for placement on parole if 3 conditions are met. The conditions are that the inmate is suffering from a terminal disease or condition, or if such inmate is rendered physically incapacitated as a result of injury, disease, or illness in such a way that it limits their daily activity or their ability to care for themselves. The second requirement is that their risk of reoffending is low. And the third requirement is that there are appropriate arrangements for their supervision, care, and treatment within the community that they're going to be released into if they are released on medical parole. So our reading of the Act is that all three of those conditions have to be met. You will note that the first condition is where the inmate suffers from a terminal disease or condition. And this is where, within the scheme of medical parole, the Medical Parole Advisory Board steps in because of who sits on the board and their expertise that constitutes the board. So while a person applying for medical parole might have a doctor apply on their behalf or someone else apply on their behalf, there is also an independent body in the form of the Medical Parole Advisory Board that sits to evaluate the medical conditions at hand. And in addition to their own expertise, they might actually call for other opinions medical opinions to be provided on the matter at hand. And it is upon that basis that they would then make a recommendation to whichever party is eligible to be granted parole or medical parole at the time, as to whether this person is suffering from a terminal disease or condition or is rendered physically incapacitated, so as to limit their activity or ability to care for themselves. So, you know, when we look at the role of the Medical Parole Advisory Board, we look at the expertise that they bring to such an instance.
And Nabila, let me jump in here, Nabila, quickly. Apologies if you can hear me. Does Mr. Zuma's status as a former president infer some level of respect in situations like this?
Are we saying respect, or are you saying differentiation? So from a legal perspective, my understanding is that our Constitution provides that for everyone is equal before the law. So all cases of applications of medical parole would be treated the same way, or at least should be following the same procedures according to the law.
So let's come back to you, Mzwanele, and you know, his lawyers say he needs 24-hour daycare. Should there be concerns about laying precedents for the future?
No, look, it's a pity that I don't know if you had a Google so that we can show this up very quickly. If you were to actually open this act, Correctional Services Act of 2014, and just to help Afriforum navigate this act, is actually very simple. If you go to, I'll remind him again, if you go to Section 75, subsection 7, you will see the issue of first about the jurisdiction and the fact that he might need, he needs a medical report. And also when it talks to this issue of independent advisory panel, it says additional report as it were. So it's not like a be all and end all. That report is an additional thing right there in the act. As I say, it would be nice if you could Google it as we speak, so that we can actually just set this thing straight. It's additional, it's not a be all and end all. That's the first thing. The second thing, the Section 79(1) has got no advisory anything. It talks about the parole board, talks about something very different. And it's important that people must understand how to read an English sentence, because there it lists people that can do this. In Section 79(1), it says something about the Commissioner of Correctional Services, comma, and then it says parole board, comma. Now, a parole board is not interchangeable with a medical advisory panel. And this is a confusion of these right-wing groups that they don't seem to comprehend, that the parole board mentioned in Section 79 is not the same thing as the medical advisory panel that you need. So they're just confusing things. So and by the way, and the issue here is that did the person, so there's no precedence of anything wrong. The law has just been applied. It's just that you've got very hateful people, very vengeful, very malicious people that just hate President Zuma.
But again, why do you think this is all politics? Because you say vengeful, hate. Why do you think it's all that?
Yeah, because President Zuma is known in South Africa as a president that has been pushing a lot of things for transformation, for advancement of black people and all of that. Ramaphosa has come to reverse all that. That's why he's a darling of the white people.
And again, quickly, let me put this. If you say the former president is all that, why didn't he simply obey the laws? Because it's an issue of contempt in the first place. He thought he was above the law and he refused and he dared the people and the law.
Yeah, but again, no, that is another misconception. You need a whole thing to know what happened here. President Zuma was first supposed to go to the Commission of Inquiry or whatever, Zondo Commission so-called. And then he actually went there for 3 days, actually, that he was there, up until he discovered that Zondo is biased. And then he applied the law. He went to the review court to say, he went to court to say Zondo must recuse himself. In fact, before that, he went to Zondo to say, Zondo, please recuse yourself. Do you know what Zondo did? Zondo put his own affidavit there to say there is no conflict between me and you. So at one point in time, we had Zuma's affidavit and Zondo's affidavit. And guess what? Zondo decided on these two affidavits, and he decided that his must take precedence. I mean, can you imagine the mockery that we've just gone through in this country, that a judge that makes a decision on his own case, basically. That's what happened. And then President Zuma said, well, if that is the case, your decision must be reviewed. So by the time Zondo ran to his subordinates at the Constitutional Court, because at the time he was the most senior judge, the real Chief Justice had retired or on leave or something, was not there. So he was the most senior person. So he goes to his subordinates to report this case, and they take this case. And in fact, instead of referring him to the trial court so that President Zuma can respond for himself, they don't refer the matter to the trial court. And if you actually look at the substance of the matter, this is not the kind of thing that you take to the apex court. I mean, for somebody that it did not go to attend a meeting in some commission.
Let's close on this.
To the highest court in the land.
Mzwanele, apologies. Let's close on this because I've listened to you. And Reiner, you've heard him, and this he says it's smack of politics. And Zuma's sentence ends in October. Is there any moral justification for asking him to go back to jail at the moment, especially if that may incite violence?
Well, I think we have to get back to the equality before the law. We cannot give special treatment to people simply because they are prominent politicians. So in this case, I also want to get back to Mr. Manyi's interpretation of Section 79. Simply, I think there's a bit of a misunderstanding here. The fact that Mr. Fraser is allowed to overrule the body's decision does not mean that the fact that that decision is rational. So you have to provide justification. And the fact that Mr. Fraser does not provide any sufficient justification for his decision means that this does not pass the rationality test, and it means that his decision has no ground to stand on. That is the simple fact of it. Now, in terms of the moral aspect of Mr. Zuma's imprisonment, we strongly believe, again, like I mentioned, there should be no special treatment for anyone. The Medical Advisory Board found that Parole Advisory Board found that Mr. Zuma was indeed not terminally ill and could serve his sentence. So there should be no special treatments in this regard. Unfortunately, that is the way that our Constitution clearly stipulates it should work.
Well, I'd like to thank you, gentlemen, Reiner, Duvenage, and of course Mzwanele, Manyi, and Nabila Mia, who also took time to join us. Thank you for your time, and we do hope that we'll stay on this, and we do hope that, as you both have said, justice will prevail.
Thank you very much.
Thank you very much.
All right, I would like to thank you for watching I'm Sulaiman. Bye-bye.